part of the webinar is able to connect, and then after 2 minutes, we'll set off. Thank you. Good afternoon again, everyone. Like I said, this is Nisha Hendricks speaking. I'm from Legal Aid South Africa, and I'm part of Pillar 3, that is part of the NSP Collaborative. We bring you today's webinar as part of a series of webinars that is aimed at bringing awareness of the Amendment Acts and the changes that it will bring about, the benefits it will have for survivors of GBV, and the differences that it will bring in terms of implementation in courts and interventions for survivors and beneficiaries. So today we have Jackie Wessels. She is the regional court president in Limpopo. She is passionate about access to justice and passionate about making the wheels of justice turns quicker. So she, for example, is at the forefront of making sure that the justice system moves with the times and technology, and seeing how we can use technology to create better access to justice for people, for survivors of GBV especially. And so today we'll focus on the audio visual, or making testimony available through audio visual links. That is something exciting. It is something that has already been used, but we will see how we will increase the use and see how the Acts makes provision for increased use of this, as well as the use of intermediaries. So intermediaries is something that's already part of our system. But what the Amendment Act now provides for is an increased use of it in terms of civil law as well. So that is something exciting. It has not been available before. And Yaki will speak to us about how it will be now made available in terms of criminal as well as civil, increasing the access in terms of the number of categories where it can be applied, but also increasing it to civil law as well. So there we have it. Yaki, you can proceed.
Thank you very much, and thank you for that introduction. And good afternoon to everybody that is joining. Yeah, I've been a little bit too much on the screen, I think, since yesterday, because this is the third one in 2 days. It just worked out that way. Please note, I'm not the only one doing webinars. There's a whole host of my colleagues that has been doing webinars on a variety of different aspects that deals not just with, we've tried to break it up to deal with specific aspects of the different legislation, to also have it a little bit of more in a bite-sized format for everybody, because it can be a bit much if you look at everything at once, because it's so much. I facilitated a webinar last week dealing sort of specifically with the impact of the amendments on intermediaries in particular. So I'm not going to deal with that today. I thought today what we are talking about is how, through the use of audiovisual link testimony, as well as having intermediaries available, we can ensure that we're improving access to justice, as well as the ability of people, parties, witnesses to participate in court proceedings. Because in the end of the day, it doesn't help. We have a justice system that is not accessible to people. And yes, as Unanisha was saying, I am passionate about looking into how we can make use of technology in order to ensure that we actually increase access to justice. As we all know, we cannot keep on doing things in the same way and expect that there be different results. There is a problem for people, or it is difficult for people to get themselves to courts. And we need to look at ways that we can assist people to ensure that they're able to access justice without all of the blockages and hindrances that you find in being able to go to, basically, to a court, not having proper transport, and a variety of other different issues that comes up in order to be assisted, and or to have your day in court in order to be able to tell the court your side or your story about what happened to you as a witness. But firstly, let me just start off. In South Africa, we actually do have a service charter for victims of crime in South Africa. And sometimes I think we forgot a little bit about this. And it is important that we understand the importance of the service charter. This was not just somebody's idea of doing something. And this is actually mandated in terms of the Constitution. Now, the objectives of the service charter is that we need to look into ways to eliminate secondary victimization in the criminal justice process. And we have to ensure that victims remain central to the criminal justice system. In other words, we need to have a victim-centric focus for the criminal justice system in particular, but also for the justice system in general. There is a need to clarify the service standards that can be expected by and are to be accorded to victims when they come into contact with the criminal justice system. And we have to make sure that provision for victims' recourse when standards are not met. Now, what are your rights as a victim of crime? Now, in terms of the service charter, it mentions that you have the right to be treated with fairness and with respect to your dignity and privacy. You have the right to offer information, the right to receive information, the right to protection as appropriate, the right to assistance, compensation and restitution where applicable or appropriate, depending on what it is all about. It sounds all good and well on paper. The issue is, however, how do we ensure that parties can access the justice system and that they are able to participate within the justice system? So, from my perspective, an important aspect to the rights of witnesses in general, parties, they have to be able to fully participate in court proceedings. And they have to be given the opportunity to have their voices heard. Now, we have been having protective measures in our courts for criminal cases in particular for a very long time. For example, depending on the circumstances and the kind of case, for example, with sexual offenses, a witness can testify in camera in certain cases. So in camera means that no other people are allowed in the courtroom apart from the court personnel and the relevant parties that need to be in the court. So in order to assist the victim, to preserve dignity, and that the victim doesn't have to testify about embarrassing detail with everybody gawking at them. We also, for many years now, since around 1994, have been using CCTV systems. Not all the courts have a CCTV system, but a lot of the courts, in particular in the regional court, do have the closed circuit television systems that is linked up with a testifying room in the building, so that a victim can testify outside of the courtroom, elsewhere in the court building. There have been measures at some of the courts with regards to having separate waiting rooms where there's space, in order to assist with reducing secondary trauma. But you do not actually need to be in a court building to testify, because you can also use a remote audiovisual link to testify, just as we're having the webinar today, making use of an audiovisual link. In certain circumstances, for certain categories of witnesses, you can also have an intermediary to assist, to ensure that you're able to fully participate in court proceedings. I will talk a little bit more about in which circumstances a witness can be provided with an intermediary. It is very important that we make sure that when people are having to go to court to testify in a case, that they know what their rights are, what the different options are. Because we found it way too many times that people are coming to court and they've got no idea of what to expect. They don't know that there's different options, that they don't actually always need to be physically inside the courtroom, or that if they are there, that there may still be an option to, for example, testify in camera, and that there would not be a gallery full of people listening to what had happened. For us that is working within the court system, in the court buildings, I suppose it's easy for us to forget about the fact that we are working there, we're used to the place, we know how it works. But for most other people, they have no idea how how to deal with the idea of going to a court. And unfortunately also, a lot of time people have got a wrong idea about how cases are dealt with, and how things are done in courts. These TV dramas and so-called reality shows that they're seeing. Criminal courts, our courts don't work like Judge Judy. We don't have juries like they show in those American dramas. And it gives a false idea of people as to how things actually work at our courts. Prior to COVID, the reality was, however, that often our courtrooms will look like this, crowded and packed, with a lot of people everywhere. Because of the fact that even though we had a provision in the law in regards to criminal cases that a witness can testify using electronic media, it was not really used. We've been using the CCTV, the closed circuit television at the courts where it was, or currently is. We've used that a lot, but we haven't really used technology to the full extent that the law actually had been allowing us to do previously. In 2018, there was an article in Intermediaries that appeared that were talking about the courtrooms of the future, looking at virtual courts and e-justice and video conferencing and e-filing, where it was talking about the advances in technology can improve the courts and the public's access to court services. Not only will new technology allow for greater access to the courts, but it can also improve the efficiency of the courts operating in difficult financial times. I had been trying to get us to be able to use remote audiovisual links for a long time prior to COVID. And that was the one silver lining with COVID. Suddenly, we were able to get access to audiovisual platforms, and it became much, much easier to move towards virtual courts. This is a photo of one of my colleagues' courtrooms. On that day, apart from one practitioner in his court, all the other practitioners and parties had been virtual. And we had very quickly learned that we're actually able to be very effective and save a lot of money also for parties by utilizing audiovisual links and having virtual court hearings, which we'll talk a little bit more about. So, just a little bit of background. For quite a number of years now, there have been provisions in the Criminal Procedure Act dealing with audiovisual remands. However, this was still a fixed system between certain courts, a specific courtroom at some court buildings with a specific prison, and it is being utilized mainly for months of those awaiting trial in custody and for certain bail proceedings. So it has limited use. Not all of the court buildings are connected with the prisons, and so, but that has been around for quite a long time. As well as I've already indicated previously, we have Section 158 of the Criminal Procedure Act that is dealing with the testimony of witnesses and accused through the closed circuit TV system and other electronic means. It has been quite clear in terms of the existing case law that the provision in terms of Section 158 of the Criminal Procedure Act can be used for remote testimony of witnesses. Though there had been some conflicting case law as to whether or not it would only be able to be utilized for witnesses inside the country or also for those outside the country. Then, as I've indicated, we had COVID, and there was ministerial directions that has been issued as a result that had really opened the path for making a lot more use of audiovisual testimony. And the Criminal and Related Matters Amendment Act of 2021 make amendments now to the Magistrates Court Act, as well as the Superior Courts Act and the Criminal Procedure Act, ensuring that an audiovisual link will be able to be used for testimony in all proceedings. It doesn't really matter whether or not it is a criminal case, a civil case, a maintenance matter, a domestic violence case. Witnesses will have the option of being able to testify remotely using the audiovisual link. And also it's been clarified now in the law that it does not matter whether or not the witness is inside or outside of the Republic. What happened when COVID started was that our courts, such as the Supreme Court of Appeal, the Labour Courts, Labour Appeal Court, and in particular the Gauteng High Court directives were issued very, very quickly to provide for virtual or audiovisual appearances as well as e-filing. And the Chief Justice then gave directives that each head of court can give directives. And we had issued directives in regards to e-filing and audiovisual appearances. Now, the e-filing in the lower courts, as well as some of the other courts, were more a question of emailing, but that as the online portals for the utilization of e-filing purposes is still in the process of being developed. That would be the next way that we would be utilizing technology to make it easier for parties to have access to courts and court processes and systems, so that instead of having to go to court to hand in an application, for example, for a protection order in person to the clerk of the court, once the amendments come in operation, you would be able to actually email it. And once the online portal is up and running, you would be able to submit it via the online portal through the internet. And you will also be able to appear virtually through the audiovisual link for any hearing. So you actually do not need to get physically inside the court building to be able to have your matter dealt with. In the COVID directions by the Minister of Justice, that the first ones were issued on the 3rd of May 2020, and there were a couple of subsequent directives issued, but they were all more or less similar, where the definition of a courtroom was extended to include an audiovisual link to a court, and it provided in regards to civil cases as well as other cases, any proceedings, that there's a discretion to authorize the hearing of it through teleconference, video conference, or any other electronic mode, which dispenses with the necessity to be physically present in a courtroom. Now, I have to say in the beginning, a lot of people were uncomfortable to change the way that we've been doing things. But once parties have started appearing virtually and realized how much more effective that could make court processes, as well as how much more convenient it had been, we have been doing this more and more and more. You know, in some of our cases, a witness may need to come through from one province to another. It may need to travel for a day to be at the court where they have to testify, maybe for an hour or two, and then have to travel all the way back, taking 2 or 3 days out of their lives just to get themselves to court. If you're able to testify through an audiovisual link, it is just the hour or two. You do not need to do all of the traveling and everything else that needs to go with that. In the beginning, in April 2020, there was an issue raised as to whether or not, for example, there was a bail application that could not proceed. But in that matter, there was also a finding that even a bail application can proceed using a remote link. The section 158 in the criminal procedure that I've been talking about has always read that a court at its own initiative, but from the court side, or an application by the prosecutor, order that a witness or an accused give evidence by means of closed circuit television system. The accused can also make the application for doing this, as well as a witness. It's quite clear. So anybody can make the application, or the court can, on its own initiative, order this. Normally, parties would be addressing the court for this. The court can only make the order if the facilities are readily available. And these days, with the development of technology, at least that is the one thing. Audiovisual links are now very easily, very readily available or obtainable. If that is there, and it would appear for the court that it will prevent unreasonable delay, save costs, be convenient, be in the interest of security or public safety or interest of justice, or prevent the likelihood of prejudice or harm if to any person, if they testify or is present at such proceedings. Now, the court doesn't have to have all these reasons. Any one of these reasons would be sufficient for the court to be able to make such an order. Where necessary, the court can give directives to ensure that the process will be easy to manage and working easily. As long ago as in 2013, in a matter in the High Court, the judge mentioned that in granting one of these applications, specifically for a remote audiovisual link, that everybody would be able to observe the witness. There's an immediate video and audio link, allowing for questions to be addressed to the witness's responses to be noted and observed, and the witness would be in a position to see the court and all the protagonists. In other words, it does, even though the person is not physically in the courtroom, it doesn't take away from the ability to testify, answer questions, be cross-examined, be able to see everybody in court, and for everybody in court to be able to see and hear the witness in itself. So therefore, it would not impact on the accused right to a fair trial in his presence, because in his presence, in this circumstances, does not have to be in his physical presence. Now, as I've indicated earlier, the amendment to the Criminal Procedure Act in Section 158 clarifies whether that witnesses can be in or outside of the Republic when they testify using the audiovisual link. And then there's the amendments to the Superior Courts Act as well as the Magistrates Court Act, in terms of which evidence for audiovisual link in proceedings other than criminal proceedings is now being specifically included in our legislation. The only real difference is to the current 158, and as it's amended, is the bit about irrespective of whether the witness is in or outside the Republic. And then there was also, just for purposes of subpoenas, it was stated that if a witness is outside the Republic, gives evidence by means of CCTV or similar electronic media, it is regarded as a witness who was subpoenaed to give evidence in the court in question. Now, when we are dealing with remote audiovisual testimony, it's very convenient, in particular for the witnesses, because they do not have to sit around the court the whole day. If you testify using an audiovisual link, normally a specific time will be arranged for you to link up. It really assists to reduce secondary trauma and also potential victimization at the court, which often is or sometimes can be experienced by victims and witnesses when they come to the court building, where they may see friends or family of the accused or other people that would potentially be intimidatory to them. So it really does assist the courts to be more efficient and effective. And in general, it's quite cost effective for all. And it saves a lot of time and money. So what is necessary apart from well, obviously we need the necessary devices with a camera and a Wi-Fi or data or access to it. And then in order to make the arrangements, they would need a contact number or an email address to which the remote audiovisual link can be sent through to. And it is extremely important that we need to make sure that witnesses are aware that testifying using a remote audiovisual link is an option. It is possible. They don't need to take leave for the whole day or go, unpaid leave for the day. It's simply because of the fact that they need to testify. Arrangements can be made that they're available at specified time to testify using a remote audiovisual link. It's true that not everybody always have access to a device with a camera and or data or Wi-Fi. But what we have been doing as well is that alternatives can be arranged that the witness testify from elsewhere where such is available. We've had witnesses that, for example, is in a different province and need to testify in a court far north. And that arrangements then are being made that the witness can go to the closest court, and that between the court managers, they make the necessary arrangements that the witness at the court that is close to them get linked up with an audiovisual link to testify in the courtroom at the court where the case is being heard, so that they do not need to travel all that way to get to the court, but that there's an alternative available. On next week, on the 4th of August, there will be a webinar as well, facilitated by the MPA, where they will also talk about the extension of services at the Thuthuzela care centers. And one of the part of the services that they're extending is that they are getting the relevant equipment and connectivity to ensure that witnesses would actually be able to testify from the Thuthuzela care centers and do not need to go to the court building in order to testify in gender-based violence matters at the 60 Thuthuzela centers that is around the country. Hopefully that would be extended, but at least that would be one option. For witnesses that need to testify, that don't have their own devices, and or that feel that they would need assistance and don't want to do this on their own. Yeah, we all know about load shedding, and yes, there are some challenges of connectivity in certain areas, but we are looking into obtaining this boosters or amplifiers at courts where there's connectivity issues to ensure that there would be sufficient connectivity to enable us all to make more use of audiovisual testimony in cases. If you've got data and the laptop's battery is full, you can get somewhere depending on how long the load shedding is. But yes, unfortunately, that is also one of the challenges. But we all have learned to adjust our court times to go with load shedding in order to not lose out on too much court time. Now, the provisions that is included in Section 51C of the Magistrates Court Act and Section 37C of the Superior Courts Act read very similar to what is in the Section 158 of the Criminal Procedure Act. Basically, that a court on application by any party or on its own accord can order that a witness, irrespective of whether the witness is in or outside the Republic, if the witness consent, give evidence by means of an audiovisual link. You will see that the reasons that the court can make the order, if it appear to the court that it will save delay, cost, convenient, prevent the likelihood that the person may be prejudiced or harmed, or otherwise be in the interest of justice. The facilities available or obtainable and the audiovisual link that is used by the witness or at the court enables persons at the courtroom to see, hear, and interact with the witness, and the witness who gives evidence to see, hear, and interact with the persons at the courtroom. If a party is asking and whether or not the court is allowing or refusing an application, the court must give reasons for that. Audiovisual link is, for this purpose, also defined as facilities that enable both audio and visual communication between a witness and persons at a courtroom in real time as they take place. In Uniform Rule 38.9, these are the rules for the high courts in civil matters. We've actually already had included on the rules that came in operation on the 1st of February 2022 that as part of the trial process, provision has been made for witnesses requiring to give evidence through audiovisual link, and also as part of the judicial case management process, one of the aspects to be looked into by the parties would be where the evidence is going to be done through audiovisual link of any of the witnesses. The Magistrates Court rules has also had an amendment that came in operation on the 8th of July this year. And Rule 25, for example, is the Judicial Case Management and Pretrial Conference Rule, which you will see one of the aspects the court need to discuss and take into account, and the parties as well, is the taking of evidence by audiovisual link. In other words, which witnesses would want to testify or might be able to testify through audiovisual link, obviously, so that the necessary arrangements can be made. One of the rule changes that is being proposed and was sent out for comment earlier this year and is already been dealt with by and approved by the Rules Board is amendments to Rule 64, which deals with the attendance of witnesses in criminal cases. Now, the proposed amendment specifically deals with the subpoena that is used in criminal cases for witnesses and that the form of the subpoena actually be changed, including to specifically have as part of the form to tell witnesses of the possibility of being able to testify using a remote audiovisual link, as well as to include on the subpoena the information who the witness can contact at the court to make the necessary arrangement to get an audiovisual link to testify remotely. In the rule amendments, there will also be made provision for the fact that a subpoena can be served electronically on a witness as well. Now, in 2013, Judge Satchwell had referred to the fact that it's almost right that video conferencing is an efficient and an effective way of providing oral evidence, both in chief and in cross-examination, and that this is simply another tool for securing effective access to justice. And she refers here to the view expressed in a judgment years ago that our rules of court did not initially refer to anything other than pen and paper. They advanced to encompass the concept of a typewriter, then the computer, thereafter the telefax, and now email. Why video conferencing or other technology should be excluded is beyond me. It is extremely important that we really look at how technology can improve access to justice and also how it can make the justice system more efficient, effective, and overall accessible for all. So the virtual court is no longer the court of the future, but it's very much the court of today. Anybody, be that from the presiding officers, any of the parties in cases other than criminal, in criminal cases, a prosecutor, a legal practitioner, a witness, and even an accused, none of them have to be physically in the same court or building or town or province or even the country, but all can be in the court or appear in the court remotely together through audiovisual links, just like we are now gathered here in this webinar from all over. Essentially, as long as we've got a laptop with a webcam in the court that is linked on an audiovisual platform, the webcam or a separate camera so that the person can see and hear all in the court, and HDMI cable to put it up onto the biggest screen or monitor so everybody can see, especially if there's some parties in court and some virtual, and obviously that it can be recorded. We're able to deal with these cases. So audiovisual appearances or hearings and testimonies really do reduce the need for people to come to court whilst the matters are still being dealt with. And this is not just a COVID initiative. It really does make a difference. So, and it's not just in our country where this is happening. This is really across the world. Prior to COVID, in various jurisdictions in the world, they had started to use audiovisual appearances and e-filing or being able to electronically file and submit applications, etc., to court through a online portal. In some of the countries, even prior to COVID, you virtually have had the courts that just function virtually, particularly with civil cases and some other cases, family law cases. It's relatively easy to do that, where the judicial officer does not even need a courtroom. They simply would sit in the office as long as they can have it recorded, and where necessary have the interpreter around. It doesn't matter, matters can be dealt with very effectively. It is also very convenient, in particular for our expert witnesses. And more of them are requesting to testify virtually. But it's not just for the witnesses. We have also found that, in particular with your civil and other cases, it's very convenient for your legal practitioners and parties as well. When you appear virtually on the link, the court will think basic information, date, court case, parties, representatives, and who's in court and who's on the audiovisual link or teleconference, and from where they are linking will be put on record. That will be put on record and clarified that everybody can see everybody and hear everybody clearly. And the court will normally invite the parties to speak so that everybody is not speaking at the same time. You would be able to use your raise the hand function if need be. If you're not speaking, you're supposed to be on mute. And the important thing is video should be on when you are speaking or testifying. So while you are testifying as a witness, your camera must be on and unmuted. There should not be any background noise, or if you can't help that it is an area where there may be some background noise, there's always the option to wear the noise reduction earphones as well. There should also not be anyone else with you in the space where you are testifying unless the person is authorized by the court. One of the things that they're looking at is at the different court buildings to have little cubicles as testifying areas for people that want to come to the court to testify in another court further away instead of having to drive through. So, like I said, it doesn't even always have to be a room. It could be like a cubicle with noise reduction earphones. As mentioned, there is also the extension in regards of the utilization of intermediaries. Up to now, intermediaries have been used in criminal cases only, and it was specifically for children and people with intellectual disabilities that is intellectually under the age of 18 years. These categories will now be extended so that there would be additional categories of persons that can be assisted by intermediaries to better participate or fully participate in court proceedings. Section 170 capital A of the Criminal Procedure Act is the provision that deals with intermediaries in criminal cases. But now in both the Magistrates Court Act as well as the Superior Court Act, sections 55 capital A and 37 capital A, respectively, had been inserted, which now authorize the use of intermediaries in all other proceedings apart from criminal proceedings. So if it is a civil matter, whether or not it is family law matter, and there's a need for an intermediary, then the party or witness needing an intermediary will be able or allowed to use an intermediary. One of the sad things that have happened is, for example, for sexual offenses, you would be able to use a CCTV, a remote link to testify. You don't have to be inside the courtroom. If you were under 18, you would be able to utilize, for example, an intermediary. But if you then go to a civil court and you are suing a party or a school or whoever in regards to that for damages suffered or experienced as a result of, for example, the sexual assault. If you're in the civil court, you could not use the CCTV, you could not use an intermediary, and you have to actually testify inside the courtroom. And it is clearly, if you think about the fact that if you look at the Constitution and Section 1, part of the right to equality includes the right of equal protection and benefit of the law. And it would make no sense as to why, with certain types of cases, you have these protective measures, but with the other types of cases in our courts, there's no protective measures. Because it is true that a case may be a criminal case today, but it doesn't mean that they may not follow a civil case out of that matter, for example, for damages. So we need to ensure that witnesses are able to be treated with the same benefit, regardless of what kind of case it is. One of the other aspects is that additional professionals had been included in the list of persons who will be competent to be appointed as intermediaries. This is to ensure that the different skills that might be needed to ensure and to enable and afford witnesses with different needs, that they are all able to be accommodated. So the persons that will be used as intermediaries will not necessarily all be able to be intermediaries for all categories, because they may have the skill and experience to assist an older person, but they may not necessarily have the skills and the experience to assist somebody with a particular physical disability. It is important that we recognize that we cannot have a one-size-fits-all approach when we are dealing with protective measures and ensuring that we accommodate the needs of our witnesses and also in particular persons with different types of disabilities, to make sure that they are in a position to actually participate in court proceedings. So when we are using the intermediary for criminal or other proceedings, the court can appoint a competent person as an intermediary for the following categories of witnesses, where it's a witness under the biological or mental age of 18 years, or a witness who is suffering from a physical, psychological, mental, or emotional condition, or who is an older person as defined in Section 1 of the Older Persons Act. The intermediary would then be appointed to enable such a witness to give the evidence through the intermediary. And the court can do this if it would appear to the court that the proceedings would expose such a witness to undue psychological, mental, or emotional stress, trauma, or suffering if he or she testifies at such proceedings. Remember in the beginning when I was talking about the service charter for victims of, it's very important that we ensure that secondary traumatization is reduced as far as possible. And this is one of the ways through which such can take place. So what does it mean to have an intermediary? It means that there would be no examination, cross-examination, or re-examination of a witness. That will take place except through the intermediary. The only exception is if the court specifically asks the witness something. So normally how it works is that the intermediary would be the one sitting with the earphones and would be hearing the questions, and then will convey the general purport of the question to the witness so that it will be given over to the witness in a way that the witness would easily understand. but it also takes out some of the conflict or the aggression that may be sometimes contained in particular in cross-examination. One of the things, you know, in a court with all the lawyers around, they tend to talk a little bit legalese, and they tend to be long-winded at times as well, and ask questions in a way that is not necessarily very easy to understand. So part of what the intermediary would also do would be to break up questions where they ask more than one question, as in one question, and or to break the question down in a manner that would be able to understand, taking into account, for example, witness developmental level, in particular when we're dealing with children, to ensure that they're able to actually understand the questions, able to participate, able to tell their story. The legislation allows for the place where the intermediary and the witness can sit and testify from, that it can be informally arranged to set a witness at ease. It can be from, for example, a separate testifying room or elsewhere, or in certain instances where there's not the facilities available, it can actually be in a more informal manner within the courtroom, and where some of the one-way, two-way glass and or screens are being used as well. The witness would not have to see and hear the other parties directly. And however, the witness and the intermediary must be visible and audible to all in the court. And again, you don't need to be in or at the court building, because you can, for example, testify with a remote audiovisual link from the Tutuzela Care Center with the intermediary there. One last aspect that I would like to just point out is the amendment to Section 161 of the Criminal Procedure Act. Now, Section 161 deals with the fact that a witness at criminal proceedings, except where the legislation provides otherwise, give their evidence viva voce. In other words, oral evidence, talking, not through an affidavit, for example. Though there are exceptions with regard to certain evidence that can be done through an affidavit, for example. What is done is that subsection 2 had been extended so that now it reads that in the case of a witness lacking the sense of hearing or ability to speak, viva voce or oral evidence will include gesture language. And in the case of a witness under the age of 18, or a witness who suffers from a physical, psychological, mental, or emotional condition which inhibits the ability of that witness to give his or apologies, everybody. I need water. I've definitely been talking too much today. Which inhibits the ability of the witness to give evidence, oral evidence, viva voce evidence, be deemed to include demonstrations, gestures, and any other form of non-verbal expression. Now, where, for example, a person can't express themselves properly, but can demonstrate it, and this is, for example, using the anatomically correct dolls, using a picture, that would include all of that still as being part of oral evidence, as well as, for example, where a witness would be utilizing electronic or other devices in order to communicate. It will include that as well. So this has been necessary also to ensure that we have a way to ensure that there's accommodation of witnesses with different needs, which comes to the importance of ensuring that there's reasonable accommodation for witnesses, and in particular also witnesses with different types of disabilities, because it is necessary that we have to ensure that all can actually access justice. All must be able to have equal benefit and protection of the law, and all must be able to fully participate in any proceedings. And we need to understand that there's not a one size that is fitting everybody. We need to be able to assist those that need different assistance as well. We have to understand how best to accommodate each and every individual so that they are able to access justice and exercise their rights as well. About the reasonable accommodation to witnesses with disabilities, on Friday morning, the 29th, there will be a webinar that will be done by Dr. Karen Miller of the Child Witness Institute. The Child Witness Institute had done research about reasonable accommodation for persons with disabilities at court, and have really done a lot of work in this regard, and have really developed a very good way of how to approach reasonable accommodation. So I would really urge everybody to consider attending that webinar as well, or to look at the video link later on, because it's extremely important that we make sure that that courts and justice is accessible for everybody. Thank you very much. Honestly, I clearly have spoken more than I should at this stage. This morning, John was joking that my voice is not going to last.
Yes,
it looks like it might just be true.
Yes, I heard this morning, she's saying. So yes, no, we see from the comments that people were saying the presentation it was good, it was clear, and the interventions that's coming is fantastic. So now, Matilda says that made a comment that I thought funny at first, but I suppose it's a reality. She says at the moment, data is more expensive for members of the public than actually traveling to court. And we've always thought that we want to bring the court to people. We want to bring it closer to where they are. And technology is the way, and it seems that in South Africa, data, could be a little more expensive than just going to a court. Something that I can add there is in Gauteng, our high courts have moved in terms of virtual appearances. And so what Legal Aid South Africa has been able to do in some cases is, our clients can attend at our office, and we can link from our office with our clients to the virtual appearance. And in that way, we assist the client where they do not have access to data. But yes, so that was a comment from Matilda.
Yeah, but that is also why we have this arrangement that if you don't have the data or the device, etc., and we're talking here about, for example, courts in different areas or provinces, etc., you can go to your closest court. I know that we had previously spoken about the fact that you can go to, for example, a local legal aid justice center as a place, but there are also other places where there might be a possibility of free data. Maybe the coffee shop might be a bit noisy, but there are different options available. Though I must say, I'm really wondering about data being more expensive than fuel, because these days, I'm not so sure if that one is quite working out anymore.
Yeah, no.
I think data might now be less expensive. Actually, I know that people often think that if you're on virtual, etc., that you're going to use a lot of data, but for us that's been using it a lot, it's not really that much data that you might require. One of the things that I've been telling the Department of Justice to very urgently work on is that they need to reconsider how witness fees should work. Because if a witness is linked virtually, I mean, there should be a witness fee that corresponds for utilizing data, for example, and or maybe then traveling, to a closer court. And so we really need to rethink and reconsider how we've been doing things in order to ensure that we actually make this work better, because we have to. And in the end of the day, like I said, not having to spend a whole day at court for most people, and witnesses in particular, um, it's a big difference. Just the time you can save.
Yeah. Yes, no, I agree that maybe for some people that are struggling in terms of resources, we can look at the various places that we can make that resources can be made available. The idea is that access must just be easier for people than needing to have to walk to a court, have paper and pen, do things in paper and pen as we've always done it. As that court case have said, we've moved from paper to pen and then to a typewriter, etc., etc. But it's always been things that people are not able to access. So we just need to see how we make these tools more accessible for people. I see there's a hand up.
Yeah.
It is Matilda. Matilda, go ahead if you can unmute yourself.
Thank you. I thought I'd better intervene before you get to my next comment. So I'm beginning to think that data has become something more of a right, and that all spheres of government should actually be involved in getting data accessible to people. And for that reason, I don't see why our municipalities cannot also assist in that, because there is at least a library in most towns. And if municipalities could also come to the party, then perhaps they could also add a space within their facilities that they have. There's a municipal office in every town, somewhere where people have to go and pay. Maybe it can also be somewhere where they can access some data for necessary effects. But the other problem is, and I'm picking up on a later comment now already, is that the resources in our country are very differentially distributed. And I think I need to say also, just as Vessels, that you are an exceptional judicial officer. You really are, in respect of your attitude, in respect of sharing what you have, in respect of your knowledge and your attitude that you have to being part of systems. We unfortunately have a lot of judicial officers that are not with it. We unfortunately have a great many courts that don't have the facilities. Because my later comment is that, when COVID hit, the first thing I did was go to our courts and ask them what AVR facilities they had. They looked at me with blank stares. They didn't know what on earth I was talking about. When I tried to find at later stages, also because we do quite a bit of mediation for the courts, I tried to find whether they had any facilities available. We could, use people from our offices and link in, particularly where you're dealing with matters where parties do not wish to even see each other, but they are prepared to try and talk to work things out. And that was not possible to arrange. We haven't yet tried keeping one in one office at our offices and another at another office and try and get them to communicate that way. But we have tried to be quite innovative in the way that we are using. But the biggest problem is the unequal distribution of resources. So we need to find a way that we can get the resources, particularly to your deep rural courts, to your less resourced areas. And I mean, I'm in a center that is quite big. I mean, they're not the biggest of the cities, but it is a city. Thank you.
Thank you. Matilda, some of the aspects that you've been raising, very, very true. In some of the countries, when COVID hit and they've started going on to more virtual, their libraries you mentioned became a natural testifying place. A lot of places they've started using libraries, and it hasn't stopped. It's continued. Yes, with the district models, the DDM model that is being rolled out in the different countries, different areas in the country, there is supposed to be like electronic service desk or area where they will be having government services that's electronically available. So there would be an option there to actually link up there as well. So yes, one have to look at all the different options. And I mean, with regard to, for example, some of the gender-based violence matters, whatever, there's no reason why a witness would not be able to testify from the shelter, for example, where they stay and things like that. And we just need to think about it. Yeah, I know that it's sometimes not easy for everybody to be willing to do things differently. But the more demand there is for it, in particular now that it's actually going to be specifically allowed for in the legislation, it should be able to be actually utilizing it a lot more. You see, the AVR systems, yep, there's not too many around. We, in Limpopo, remember, I'm coming from a rural province, okay? And if it's possible in my province, it's possible anywhere, okay? We have huge connectivity challenges, etc. But despite all of that, we're able to do these things. I have to give total credit to my colleagues, though, as well as the other role players in my province that is willing to do things. And even though we're having rogue systems at times to just make it happen, we can have it happen. You know what we did? We've made arrangement with the prisons that WhatsApp video call. We did it through that. Worked very, very well. There's always a different way to do it. We just need to be willing to start looking into doing that. I know that generally in the regional courts, they had been, I can't really talk for the district courts because I'm in the regional court. Particular, we've really been in a lot of different areas in the country. We've been doing a lot of virtual, like I said, and particularly with the divorces, etc. That was very easy to do virtually. I know that there's mediators in my province. We've been involved with a mediation project. They've done a lot of mediations virtually. Like I said, and we've got a lot of the experts that is coming from everywhere else that is testifying virtually in our criminal cases, for example, saving the department a lot of money. So not that we necessarily have all the equipment we need. So sometimes if you need to be a bit rogue systems, then we do that as well. As long as everything gets recorded and everybody can see in here, we get matters dealt with. But I think the more we do that and the more the demand is there from the witnesses, the parties, the quicker it will be more available as well. And that is why we're talking about these things, because it is important that everybody knows that these provisions is there. It needs to be utilized. Okay. Like I said, and if we can manage to do things like this there in Limpopo, anything is possible. I hope I've answered you to some extent, Matilda.
Yes, you have, right.
Thanks, Jackie, for that. Yes, I think that, COVID showed us that we can step out of the box. Things that we thought cannot be done in another way. COVID forced us to look at other ways of doing things. And that was the good thing about it, that
Yes.
we learned to do that. You can, especially the legal profession, it was very, I don't know what is the word, conservative perhaps, and we've learned that you can do things in another way. And as Yaki has said, that when you show that you can, and make people aware of how how other people have used it and how it worked, people slowly start getting to be doing these things when they see the benefit for themselves in the system, and they become more excited and increase, and the use of it increase. So I think for us as legal professionals in the system, we need to be the ones that push for the change. We need to show that it can happen. People have done it. Let's do this. Yes.
Yes. I so agree with you.
Yes, let me just see. There's a comment from Praise. She mentions that DSD is looking, and I think that if it happens, that would even be greater. That is looking at making this audiovisual link facilities available at their wide doors and shelters, so that survivors do not need to move out of that comfortable place, or that place where they feel safe, in order to access the justice system. And if that happens, that would be great. Okay, Matilda, I see your comment that you linked onto. And then Praise mentioned something about that the Minister of Communication announced that government will look at making 10 gigabytes, I assume, of data, free data, available to every household. I know that early in the year it was announced that government will be looking at this for the next 3 years or 2 years until 2025 to be making it available. So let's hope that that materializes, and then people, as Matilda said, access to data is becoming something of a right, because access to information now includes having access to data. It just opens up a whole new world for people in terms of knowledge of their rights. Karen Holley just mentioned amazing how far we have come since the original fights for Intermediary.
Yeah, very true.
And then Izet has a comment here that the human rights organization Fair Trials has produced recommendations to guide states in setting up remote justice systems during COVID. The document states that effective participation in proceedings are essential for the protection of an accused's fair trial rights. It also notes that these rights can be violated during video hearings. For example, the accused may find it difficult to understand or follow the proceedings, and it might prevent the accused from effective cross-examination. And so our question is, are there any safeguards currently in South Africa?
I think it's important to remember that we've been doing video hearings since 1994 in this country, because closed circuit television system hearings with the CCTV systems, there's not any difference with doing it with a closed circuit TV system like we have in a lot of the courts, or doing it with a remote audiovisual link. Actually, I must tell you that with the remote audiovisual link, the picture and the sound is normally better than with some of the old CCTV systems we currently have at some of our courts. And it's also automatically a two-way system where some of the CCTV systems we have at some of the courts, especially the older ones, is still only a one-way system. So, like I said, since 1994, we've been utilizing a CCTV system. I know that a lot of countries originally had been reluctant. You know how lawyers are reluctant to change sometimes, of doing things differently. And they raised the issues about, yeah, but how are they going to access credibility and all kinds of things. But if you really look at it, and we've also had the Constitutional Court decision of DPP Transvaal that dealt specifically with the constitutionality of the utilization of intermediaries and CCTVs and so on, and child witness cases, etc. So the way that it's done now, I have never really experienced that it inhibits anybody's ability to understand the proceedings, because wherever the accused is, he needs to be able to see and hear everything, as is everybody else that needs to be able to see and hear. The picture actually, because it's a big screen in most courts, you can actually see them clearer than when they would stand there in person in the witness stand. And the matters is dealt with easier than when a witness is testifying in a courtroom, is terrified and break down all the time, and you can hardly get matters dealt with. So, yeah, and there's nothing that inhibits cross-examination. So I don't know if there's any specific aspect that she has that is of a concern, but like I said, we have not really been finding it. And like I said, and it's not really any different from the way that we've been working, utilizing CCTV systems in our courts for many years. The only difference is that they don't need to be at the court building itself. I mean, if there's concerns about what a place look like where the witness is sitting, it's very simple. You turn the device, ask that the device be turned around in order to have a clear idea exactly where the witness is testifying from, etc. So, and whether or not there's anybody else there. And as we all know, for all the meetings we've been doing, it's very quick to pick up if there's any kind of disturbance or anybody else talking where somebody is on an audio-visual link. I don't know if that really answers you.
Thanks, thanks, Jackie. Is it you wanted to add something, or you covered?
I'm covered. Thanks, Anna.
Okay, there are no further questions in the chat. I don't see any hands. Is there anybody that wants to ask any question? You can go ahead now and ask, or raise your hand so that we can call on you. Okay, I see no further hands or questions. Jackie, I think everybody is excited and waiting to see how this will actually play out in practice, and how we will deal with it. But thank you, Jackie, for the presentation this afternoon. As always, it was insightful. We are excited about the changes. Thank you for your passion regarding moving the justice system into the, I don't know, are we at the fifth revolution already now, or is it still the fourth revolution?
Something like that.
Yes, but moving us forward. You know, I've been involved with you in terms of e-justice, and I know that, you know, this is something that you think can change or make the wheels of justice go quicker. that we move into a world where, we use the resources available, the technology to make things accessible. So thank you for that. I hope your voice gets rest after today and the many presentations that you've been doing. For the rest so thank you for today. For the rest of the participants, we are having further webinars going forward in this week. If you leave your email in the chat, we can include you in the email grouping that gets the notifications of the webinar so that you are able to decide which ones you want to attend. The presentation will be made available to you. You can also leave your email in the chat and then you can then get the presentation. Alternatively, you can link into the link or the MS Teams platform that we are in. You'll see the recording. You'll be able to download the recording and then use the information that we've gone through today. So yes, it was a good afternoon. Hope to see you in other webinars. Thank you, Yaki.
And thank you very much for moderating, and thank you for everybody that have attended. And I really hope that all of you would start also looking in how you can embrace getting the system to be more effective and efficient through utilizing technology. We really should not be scared of it. But thank you very much and enjoy the rest of the webinars that's coming for the rest of the week. Like I've indicated, there's some really interesting ones that are coming in. So please tune into the other ones, or otherwise look at the links later on that will be on the Department of Justice YouTube channel, published as from hopefully tomorrow afternoon onwards. Thank you, everybody. Thank you. Bye. Oh, and a big thank you to Luwando who organized everything.
Yeah. Okay. Bye, everyone.
Bye.
Bye. Thank you, guys. Thank you.
Bye-bye.
Bye. Bye, guys.
Bye.
Bye.